We will go on with Dr. Eitan Diamond. He's manager and senior legal expert at the IHL Center in Jerusalem, where he leads the center's work on the Israeli-Palestinian context. He previously served as a legal advisor to the ICRC delegation in Israel and the occupied Palestinian territories, as executive director of Gisha, and as a researcher with B'Tselem, and he has consulted for UNICEF, OHCHR, and Forensic Architecture. He sits on the editorial board of Brill's Journal of International Humanitarian Law, Legal Studies, and on the managerial boards of Gisha, the Public Committee Against Torture in Israel and Parents Against Children Detention. He holds a bachelor from the Hebrew University of Jerusalem and a master from the London School of Economics, a PhD in law from Tel Aviv University, and a diploma in human rights from the Academy of European Law. He will address the discriminatory death penalty law adopted by the Knesset on 30th March 2026 against Palestinians in the occupied territory, and the third state obligations under the Fourth Geneva Convention, the ICCPR, the Convention Against Torture, and the ICJ's advisory opinion of 19th July 24.
Thanks very much. Can you hear me? Just if someone.
Yes.
So yeah, thanks. I'm very happy to be here. Thanks for the kind introduction and for inviting me to speak at this event, and more importantly for setting up the event. I'm not sure I'll be able to cover all that ground. I'm supposed to end my talk in 3 minutes. We're running a little late, so I'll try to condense it a little bit.
Okay.
But,
to an extent.
Okay. So thanks a lot. So I'll be speaking, as was said, about this new piece of legislation about which you've already heard quite a bit. There, of course, are many good reasons to object to any form of capital punishment, and I'm not going to try to rehearse all of these reasons now. Instead, what I'm going to do is to focus on some of the reasons why the new Israeli death penalty law is especially deplorable and in breach of international law. Perhaps that will complement some of the things you've already heard. Actually, even before subjecting this law to scrutiny through the lens of international law, its abhorrent nature is readily apparent, I would say, just by observing some of its most basic features. And what I have in mind in particular are the fact that it imposes the death penalty as a default punishment, as a rule rather than an exception, and the fact that it has been crafted to apply de facto only to Palestinians. And this has been achieved in 2 ways. First, the law contains provisions that instruct the commander of the Israeli military forces in the West Bank. This is the person who has formal authority to administer that territory, to amend the military law that Israel enforces in the West Bank, so that it will contain a provision that says the following: a resident of the area, that is of the West Bank, who intentionally causes the death of a person where the act constitutes an act of terrorism shall be sentenced to death, and this punishment only. So the rule established here imposes the death penalty as a almost exclusive penalty. I say almost exclusive because the law then establishes a narrow exception to this rule, saying that, however, if the military court finds for special reasons, which shall be recorded, that special circumstances exist for which it is appropriate to sentence the terrorist to life imprisonment, it may impose such a sentence and this punishment only. So the death penalty is the default, and then in exceptional circumstances, all these special kind of circumstances, a punishment of life imprisonment can be out. So there is a mandatory punishment of either death or life imprisonment. And if that wasn't bad enough, the law then goes on to clarify that, and I'm quoting here, in this subsection, a resident of the area, that is a resident of the West Bank, is a person who is registered in the population registry of the area, or one who resides in the area even if not registered in said registry. And here's the important part: excluding an Israeli citizen or an Israeli resident. So for the removal of any doubt, the law explicitly states that the military court, that in any case only has jurisdiction over Palestinians, cannot impose a death sentence on Israelis, even if they committed the very same act. Other troubling provisions about the part of the law that the military commander is instructed to establish provide that there is no possibility to mitigate or to commute the death sentence or for a pardon, that the penalty must be implemented within 90 days, exceptionally 180 days, and that the authority of the military court to sentence, I'm quoting here, a terrorist to death shall not be conditioned either upon the prosecution having requested the imposition of the sentence or supporting its imposition, or the sentence being unanimous. So even if the prosecution doesn't request, some of the judges didn't agree, it's a mandatory sentence. All this relates to the legislation that's enforced by Israel in the West Bank through military law. And then the new law also establishes an amendment to Israel's domestic penal law, and it provides that a person who intentionally causes the death of a person via an act of terror with the aim of negating the existence of the state of Israel shall be sentenced to death or life imprisonment, and one of these punishments only. So again, only there's a mandatory sentence of death or life imprisonment, and there's the strange requirement that the act will be an act that's aimed at negating the existence of the state of Israel, and that's very clearly designed to capture acts by certain actors and not others. This death penalty law has, as was mentioned before, been challenged before the Israeli Supreme Court and may eventually, hopefully, be struck down. But in the meantime, it's not formally on the books, which is extremely disturbing. Now, without presuming to exhaust all the points that can be made on this matter, I want to address three characteristics of the law that, in my view, render it unlawful under international law. Namely, that it is arbitrary, that it is discriminatory, and that it is annexationist. My analysis here is informed, where relevant, by international humanitarian law, which is binding upon Israel with respect to the occupied Palestinian territory, and by international human rights law, which is binding upon Israel in its own territory and despite protests to the contrary by Israel, also in occupied Palestinian territory. I am not going to specify exactly which provision, but those are the frameworks I'll be using. It's arbitrary because, well, arbitrarily killing a person is undoubtedly prohibited under international law. Article 6 of the ICCPR, for instance, explicitly provides that no one shall be arbitrarily deprived of his life. And the Israeli death penalty law violates this prohibition in multiple ways. For one thing, in order for a decision to be just rather than arbitrary, due consideration must be given to the particularities of the case at hand. This requires a level of judicial discretion in applying the law to the facts. Such discretion is especially crucial in cases of capital punishment when human life is at stake. Now, in this case, perhaps I should say, in the case of protected persons in occupied territories, such as Palestinians in the West Bank, IHL establishes, in addition, that judges considering a death sentence must be mindful of the facts that residents of occupied territory owe no duty of allegiance to the occupying power. So that should be a mitigating factor, but the Israeli law doesn't allow for that to be considered. The Israeli death penalty law inhibits this requisite judicial discretion in a number of ways, and I'll mention a few of them. First of all, by imposing a default punishment of death and a mandatory punishment of either death or life imprisonment that limits the discretion very significantly. It forecloses the possibility of mitigating or commuting the sentence and denies the possibility of granting a pardon. These are all breaches of both IHL and human rights law. The arbitrary nature of the law is compounded by provisions that undermine the capacity to protect against mistakes. which in the case of a death penalty are, of course, irreversible. So for one thing, it mandates that sentences be implemented within a tight time frame, as I mentioned, 90 days, as opposed to, for example, 6 months that are required as a minimum under IHL. Removing the requirement for unanimity in the panel, removing the requirement for the prosecution to request or support the death penalty, reducing the rank of the military judges that can impose the sentence. Another cause for concern about the arbitrariness stems from the vague formulation of parts of the law, including the provision imposing a death penalty in Israel on persons who intentionally cause the death of a person with the aim of negating the existence of the state of Israel. The meaning of this formula is unclear, and its application will depend on all kinds of subjective considerations which would render it arbitrary. Then, and this has been alluded to by previous speakers, looking beyond the specific content of the new law to the wider context in which it's to be applied, concerns about arbitrariness are greatly increased when you, for instance, one considers the deficient procedural safeguards and fair trial guarantees in the context, where among many other things, there are many, many reports of systematic ill treatment, including torture, raising concern about forced confessions or incriminatory statements. So all this was just about arbitrariness. Discrimination. So even while it's framed with a kind of thin veneer of formal neutrality, the Israeli death penalty law is designed to effectively apply to Palestinians and not to Israelis, thereby producing systematically discriminatory outcomes by facilitating differential treatment of persons committing the same act based on their different ethno-national identity. The law is discriminatory and as such actually arbitrary and unlawful, an obvious affront to justice, equality, and human dignity. Such discrimination is also a clear violation of international human rights law. The discriminatory nature of the law is all the more striking when one considers that Israeli nationals have not only been exempt from the application of this harsh measure, but also benefit from a culture of impunity, whereby Israelis who perpetrate violent crimes against Palestinians, including acts of terror that have claimed Palestinian lives, are almost never held to account. The discriminatory death penalty law also has a dehumanizing effect, and we've heard about this, cheapening the value of Palestinian lives and exacerbating concerns, among other things, about apartheid. On apartheid, I'll mention that this involves the commission of certain inhumane acts committed for the purpose of establishing and maintaining the domination of one racial group by over another and systematically oppressing the members of that group. Now, apartheid doesn't emerge from any single measure, but from the cumulative effect of a system of policies. But the death penalty law considered in isolation would not constitute apartheid. But when you consider it alongside multiple other oppressive and discriminatory policies and practices that Israel pursues in relation to Palestinians, it is a significant additional element within the totality, and it reinforces a broader pattern of institutionalized domination of one group over another, maintained through systematic oppression. Now, many commentators have already characterized this regime that Israel maintains as an apartheid regime, and I would contend that those who have harbored some doubts about this characterization before should have less such doubts in the wake of this new piece of legislation. Then I mentioned the annexationist elements of this law. So the norm in international affairs is that territory and people residing within a territory are placed under the control of their sovereign. And in situations of occupation, you have a kind of aberration in which, as a consequence of armed conflict, the territory comes under the control, the effective control of an alien power, which is not the sovereign. And IHL, through this set of rules we refer to as the law of occupation, seeks to regulate this aberration based on the understanding that it is a temporary situation and that the territory should return to the hands of its sovereign. Accordingly, among other things, the occupying power is prohibited from annexing the occupied territory or otherwise treating it as though it was part of its own territory. It must exercise its temporary and circumscribed authority over the occupied territory in clear distinction from its own territory, enforcing the territory's law rather than imposing its own, and it must govern it via a designated authority rather than directly via its own government. Similarly, pursuant to the so-called conservationist principle, the occupant is required to respect the status quo that preceded the occupation and to refrain from introducing legislative changes or otherwise disrupting the socio-political fabric of the occupied territory. Now, there are some circumstances in which changes to legislation can be introduced, but these are very constrained. And what I would say in this case is that the legislation that has been introduced does not fall within those exceptions and contradicts these basic principles of the law of occupation, which place constraints on the capacity of the occupying power to treat occupied territory as though it was its own territory. And these constraints on the authority, particularly when breached through such a draconian piece of new legislation, are all the more problematic, given the fact that was mentioned before that the International Court of Justice, in its advisory opinion in July 2024, found that Israel's presence in the occupied Palestinian territory is unlawful. And back in July 24, it determined that it should end as rapidly as possible. So an occupation that is unlawful and should end as rapidly as possible is not a set of circumstances where the introduction of such new draconian legislation is in any way justifiable. Now, to end and leave time for others, I want to go into detail about obligations that this all imposes on third parties. But what I can say is that we've been observing, and you've heard so much about it from previous speakers, a process of continuous violation of red lines that the law establishes, including through breaches of the most fundamental peremptory norms of international law. And I think this death penalty law is just another example where a red line has been crossed, and this should trigger action by other states. It's not only a matter of their discretion, they actually have obligations to respond to these kinds of violations of peremptory norms of international law. So I'll stop there for now. Thank you very much for your attention.